Welcome to the 5th episode of Business Litigation TV. This video, podcast, however you're taking in this medium, is for all business owners and business managers to help them prevent litigation and to help them avoid it in the future. As always, if you have any questions, concerns, comments, please email me at jesse@jdelaw.nyc. Again, that's jesse@jdelaw.nyc. Today I wanted to talk about strategy. And the number one of the top reasons to get a business litigation attorney is because they know strategy. They know the best tips and trades to help you avoid future litigation. What made me think of this topic today is I was dealing with a case where I have a client, and that client had an issue with their lease, and the company who was running things for the landlord. Further elaborate, the client had to shut down operations because of pipe burst. Now the lease said that they could, in the future, meaning after signing the lease, if there's any interruption in utilities, they would get a credit for during that period of interruption. Now, during that period of interruption, when a pipe burst, the landlord did not want to pay or give a credit. Now, my client, of course, had us write a letter. We threatened litigation, all this stuff. They go, okay, well, let's meet you halfway. We'll settle 4 days on, we'll give you 4 days of the 8. My guy's like, fine, I'll take it. Let's avoid the litigation. Except my guy comes to tell me there's 3 other times that this has happened, or 3 other instances. Not all with the pipe burst, but that because of utilities, they were shut down. And they wanted to pursue something for those dates. So when the settlement papers get there for the utilities, the pipe burst utility, what they did is they only did a general release, of course, for that specific time period, which works perfectly for me and my client. However, if I was the attorney for the landlord, I would say that what they did was absolutely moronic. When you're doing a release, for instance, you don't want to piecemeal all this stuff. So you should do a general release. This is from basically for all instances up to the date of the signing. You're released. You can't sue them. So what's going to happen in this case is that we're going to sign the release, and then we're going to come after them for the other 3 instances. Now, a good strategist and a good attorney would have made sure that wouldn't have happened. They'd say, listen, anything that's happened up to now, let's call ourselves good. Let's move on. And as you can tell, this is going to end up costing the landlord more money because they didn't figure out to do this. And really, it should be standard, which just tells me that they don't have a business litigation attorney or just a litigation attorney in general advising them. So again, this is long-winded, but it's about strategy. It's about knowing the correct steps to avoid future litigation. So get yourself a business litigation attorney. Consult with one. Don't do any releases that are just piecemeal. Make sure in the future they're not going to come after you for something else and something else and something else. Okay? One release, be done, move on. That's what I would have done if I was a landlord attorney. Instead, my guy is going to get more credits and have more, and the landlord's going to have more issues to deal with. So, again, any questions, concerns? I hope that all made sense. But email me, jesse@jdelaw.nyc, and I'll see you in the future.